Good day, my fellow and wonderful listeners. I bring to you yet another news. The news headline: New connection between Abba, Kyari and Nnamdi Kanu. The news in full. On 13th March 2022, it was widely reported in the media that the Office of the Attorney General of Federation issued a legal opinion advice exonerating DCP Abba Kyari from the allegation of money laundering, which forms the main basis upon which the United States of America is seeking Abba Kyari's extradition to America. Inasmuch as the legal team does not sit well with certain segments of Nigerians and even the Americans that seek the extradition of Abba Kyari, it needs to be stated that the rendering of legal opinion or advice comports with the constitutional power of the Attorney General of the Federation as preserved under the Constitution of the Federal Republic of Nigeria. Suffice if is to say that the very legal advice exonerating Abba Kyari has created a new legal connection between Abba Kyari and Mazi Nnamdi Kanu. The connection lies simply in the fact that Abba Kyari is deemed entitled to such legal advice that will surely impact his extradition. Nnamdi Kanu is equally entitled to any legal advice that impacts his prosecution. In other words, the pertinent provision of the Nigerian Constitution and Nigerian Extradition Act must be applied equally to all. Thus, Nnamdi Kanu is now entitled to same legal advice, which must include the following. Under the doctrine of the specialty which pertain to extradition by extradite fugitive, whether rendition or otherwise, is to subject position for those offences for which he or she was surrounded. Nigeria recognized this doctrine under the Section 15 of the Nigerian Extradition Act, which provides that fugitive surrendered to Nigeria is not triable for any previous crimes. Where, in accordance with the law of any country within the Commonwealth, any person accused of the offence committed within the jurisdiction of Nigeria is surrendered to Nigeria by the country in question. Then, so long as he has not had the reasonable opportunity of returning to that country, that person shall not be detained, whether under this act or otherwise, tried or otherwise, dealt with in Nigeria for or in respect of the offence committed by him before he surrendered to Nigeria, other than the offence for which he has surrendered to, or lesser offence which may be proved by the fact on which his surrender was granted. Or B. Any other offence being corresponding to an offence described in the Section 20 of this Act of the same nature as the offence for which he was surrendered, provided that a person falling within this section shall not be detained or tried for any offence by virtue of paragraph B of this section without the prior consent of the country surrendering in. To be sure that the foregoing provisions were as regard Nnamdi Kanu reached in all their material particulars. First, as on the 19th June 2021, when Nnamdi Kanu was abducted in Kenya, he was facing 4 count charges, none of which included border or terrorism. Today, the charges have been expanded to 15 counts that included that bordered of terrorism, unarguable that this is clear violation of the doctrine speciality, especially in the view of proviso that a person falling within the section, that is Section 15 of Nigerian Extradition Act, shall not be detainable or tried for any new offence without the prior consent of the country surrendering in. In the instance of Nnamdi Kanu, the surrendering country is Kenya, and there is no evidence that a consent was obtained before these new 15 count charges were brought. Conversely, the same doctrine of speciality is also recognized in the Kenya Extradition Act, which at Section 6(3) states that a fugitive shall not be surrendered or committed to be kept in custody for purpose of surrender, unless provision is made by the law of the requesting country or by arrangement made by that country for securing that he will not, unless he has first been restored or had opportunity of returning to Kenya, be dealt with in the country for or in respect of any offence committed before his surrender, other than A. The offences in respect which is surrender is requested, or B. Any lesser offences proved by the fact that before the court of committer, or C. Any other extradition offence in respect of which the Attorney General may consent to being is so dealt with. Unarguably, this provision have extraterritorial application to Nigeria because as regard Nnamdi Kanu, Nigeria is the requesting country, which fact that being affirmed by the sheer compelled presence of Nnamdi Kanu in Nigeria. Interesting, Nigeria also strictly requires the same doctrine or specialty to be respected when it comes to fugitive extradited from Nigeria to other countries. Section 37 of Nigeria Extradition Act states that a fugitive criminal shall not be surrendered to any country unless the Attorney General of Nigeria is satisfied that he will not be detained or tried in that country for any offence committed before his surrender other than the extradition offence. In the view of the foregoing, it has become necessary for the Honorable Attorney General to revisit the matter of these new 15-count charges presently standing against Nnamdi Kanu with a view to urgently issuing legal advice to the effect for all new charges to be withdrawn, for which failure to do so will amount to clear violation of doctrine of specialty as enshrined in the Nigerian Extradition Act and equal protection of the law preserved in the Nigerian Constitution. Ejimako is the special counsel to Mazi Onyendu Nnamdi Kanu. On 13th March 2022, it was widely reported in the media that the Office of the Attorney General of Federation issued a legal opinion advice exonerating DCP Abba Kyari from the allegation of money laundering, which forms the main basis upon which the United States of America is seeking Abba Kyari's extradition to America. Inasmuch as the legal team does not sit well with certain segments of Nigerians and even the Americans that seek the extradition of Abba Kyari, it needs to be stated that the rendering of legal opinion or advice comports with the constitutional power of the Attorney General of the Federation as preserved under the Constitution of the Federal Republic of Nigeria. Suffice if is to say that the very legal advice exonerating Abba Kyari has created a new legal connection between Abba Kyari and Mazi Onyendu Nnamdi Kanu. The connection lies simply in the fact that Abba Kyari is deemed entitled to such legal advice that will surely impact his extradition. Nnamdi Kanu is equally entitled to any legal advice that impacts his prosecution.